Most people think prenups are only for the ultra wealthy, but in Australia, not understanding this properly can have serious financial consequences. Hi, I'm Jaswinder, the Managing Director of Goldman Lawyers in Australia and internationally. Today, I am speaking with Ms. Kerry Turner, and we'll break down the real difference between binding financial agreements, prenups and postnups in Australia, and when you should actually be using them to protect yourself.
What are the key differences between a binding financial agreement, a prenup and a postnup? And when should you use them, Jas?
Thank you, Kerry, for that great question. Let's clear this up first. In Australia, the term prenup isn't actually used in our law. What we have instead are things called binding financial agreements, or BFAs, and they're created under the Family Law Act. So they're the same as a prenup in a colloquial sense, but we want to refer to them as BFAs. And BFAs can be broader than a prenup. You can have a BFA before a marriage or a de facto relationship under Section 90B. You can have it during marriage as an insurance policy. You can have it after you've separated. So when people say prenup, they usually mean legally a BFA before marriage. Or a postnup means a BFA after marriage or separation. The difference isn't just timing, it's strategy. A prenup style BFA is about protecting what you already own. A during marriage agreement is about adjusting to changes and your asset pool at the time, and if you have children, for example. A postnup is resolving things without going to court. You should seriously consider a BFA if you own property before a marriage, you have a business, you expect an inheritance before or shortly after marriage, you're entering into a second relationship, you have children from a prior relationship, or there is a large income gap. We're seeing a clear trend in Australia. More professionals and business owners are using BFAs to avoid future disputes. Because the reality is, court is expensive, slow and unpredictable. Here's where people go wrong. They use online templates, which cost actually more for us to review. They're not getting proper legal advice. They're signing quickly or under pressure. The BFAs are poorly drafted, or the client hasn't given proper instructions. So there's poor drafting. And if any of those things happen, and if the BFA is not just and equitable, it can be set aside. So it's not just about having a BFA, it's about having one that actually works for your situation. According to recent court decisions, the courts are scrutinising whether both parties received independent legal advice, that is, proper legal advice, whether there was any undue influence or pressure, and most importantly, whether the agreement is just and equitable in effect. The court will decide that. So while BFAs remain powerful, enforceability depends largely on how they're drafted. And the biggest mistake people make is thinking that this is something they can deal with at a later part of the relationship, because problems arise later on and you usually won't enter into one. But a properly drafted financial agreement isn't about expecting failure. It's an insurance policy. It's about protecting your future, your assets and your peace of mind. If you're considering a BFA, prenup or postnup in Australia, the best step is to get some clarity about your situation early. Of course, at Goldman Lawyers, we offer a confidential case assessment, and a senior lawyer reviews your situation and gives you some strategy clearly on the next steps.